Hello, everyone. Eric Olsen from Helps YouTube Live. Welcome to our YouTube channel today on the last day of the year, December 31st. Glad to have you here. My name's Eric, attorney for Helps. Helps is a national law firm. What we do is represent seniors and disabled persons in order to stop debt collector harassment. We do that under a federal law called the Fair Debt Collection Practices Act that provides that if you're represented by an attorney and the attorney notifies the creditor they're not to contact you anymore, that under the law, the debt collector cannot call or send you demand letters. They have to deal with the attorney, and that's what we do. We represent our clients to stop creditor harassment. I've been an attorney for 46 years now. Probably filed between 30 and 40,000 bankruptcies before Helps was started in 2012. Started Helps because a lot of seniors would come to me. I'd explain to them they can't afford bankruptcy. You don't need to file bankruptcy because your income's protected. No one's going to come after your assets. But I know if I sent them home, creditors would still call and make their lives miserable. And so when people find out about Helps and then they enroll, they give us the creditors they owe money to, we send out what's called a cease and desist letter. They leave them alone. So if you have any questions, you can put them in the chat feature, uh, and uh, and I'll address them. But I also have things that people have inquired of us that I'll read. The first one is a person from Oregon, ages 75. Their only income is Social Security. They rent. He owns his car outright. His credit card debt. He has one lawsuit, and he had a stroke and couldn't work anymore as an accountant. And he can't afford the debts anymore. He apparently owed some taxes. So we sent him an email we have on how to apply to get on currently not collectible status, which he could get on. He may not even need to do that. If his only income Social Security, IRS may just send him notices, may not try to do anything. Anyway, he enrolled with Helps and we solved his problem. So he doesn't have to deal with the collectors anymore. They're not going to take his car. And he was being sued, so he gave us the lawsuit information, and we sent a letter to the attorney who sued him, letting the attorney know that his income was only Social Security, he couldn't afford to pay the debt, wasn't going to pay it, so he doesn't need to go to court. Okay, so if any of this stuff applies to you, let you know, uh, listen up, and you can always call us. Number down below, 855-435-7787. And again, greetings. Happy New Year to everyone. Last day of the year. Good to have you here. So, person calls us from California, says, I need financial help paying student loans. School loans, have not been able to work due to cancer and related issues. Well, okay, first off, right now, the Department of Education back in, I think, first part of June, announced that they don't intend to offset Social Security to pay student loans. For a long time, the government's been able to send a letter saying they intend to offset 15% of Social Security. That was stopped around 2018 when Helps was a party to a lawsuit with a class action lawsuit against the government, and to change the procedures so that uh, seniors especially could qualify to get on uh, an income-based repayment plan for student loans. It was too complicated. That lawsuit was eventually dismissed, but then because of COVID and other reasons, um, the government hasn't been coming after a percentage of your student loans, of your Social Security. They were going to start doing it in May, but then 30 days later they announced they weren't going to do it, and they haven't done it since. And I kind of doubt they will, at least for a while. So we would tell this guy that you know he he's got cancer, he's probably not working, so he's getting Social Security. He doesn't need to worry about the student loans. Now, if they ever did start to take 15%, then there will be a program, an income-based repayment plan. A lot of the seniors, especially with lower or modest income, won't have to pay the student loans. They can get on that plan and there won't be a payment. Okay? Or, thank you, everyone. Okay. Now, once again, if you got any questions, you can always call us. Okay. This one calls in. It says creditors harassing her nonstop. Uh, this is what the note says. It says her Social Security disability is reduced due to exceeding the allowed bank amount limit by $6,000. Discussed her protections and that she didn't need to worry, and apparently she was enrolled for free because she's not getting Social Security disability. That was a mistake. She's getting SSI. Okay. See, there's different types of Social Security. Um, Social Security, regular Social Security is when you retire, you start getting at 62, or you can get full benefits at 66 or 67, 66 in a few months. Or if you're younger and you get injured, you can get on Social Security disability. Um, and then when you turn, 65 or a certain age, then it goes into regular Social Security. Now, if you don't have enough Social Security credits, if you haven't worked enough, then you may be able to get on what's called SSI, which is under the Social Security program, but it's more like a welfare benefit. It's based on people that haven't worked enough. Okay, but it's a minimum amount that you receive. Now, in order to qualify from Social Security income, SSI, one of the requirements is you have to keep your bank account below a certain amount. If you're single, 2,000 or less. If you're a couple, 3,000. So when this person says they got um, that it was reduced because their bank account went over $2,000, um, that's because they didn't qualify. So there are, if you get SSI, you have to keep your bank account under a certain amount. Okay. Um, okay. So this person asks, does it matter if my Social Security goes into a checking or savings account? Well, it can matter if you're sued. Okay. If you're not sued, I don't really care. But if you're sued, see, there's a rule went in effect in 2012 that tells banks that if they get a writ of garnishment, they have to examine where money came from. And if it came from a federal source that was deposited in your bank account, like Social Security or VA benefit, they're to take that amount, times it times two, and they automatically protect that sum in the bank account to which it's deposited. Therefore, we tell people if they're sued, they should generally just have one bank account, and that's probably Social Security, probably checking, where you're just checking account. Okay, so we got 1,500 in Social Security, 3,000 in the checking account to be protected. If you had money in the savings account, it's still protected, but it's not protected automatically, which means if they sued you and got a judgment and they garnished your bank account and you had $500 in your savings account, and that's not where your Social Security was deposited, then the bank has to turn that money over to the creditor. So it may still be protected, but you'd have to file a claim of exemption or challenge the garnishment to get that money released, which can be a headache. So it's solved by just keeping it into the account, keeping all your money in the account to which Social Security is protected. Okay. But once again, for any of you, if you haven't been sued, you don't need to worry about this. Now, if you get sued, can they do it right then? No, they'd have to get a judgment, and that usually would take, oh, I don't know. Can't imagine a judgment would be any sooner than a month, usually 2, 3, or 4 or 5 months or more. Okay. So you'd have plenty of time to arrange your finances so your Social Security goes into just one account. And if you have to have a savings account, just leave it at $5 or the minimum amount. Okay. So this person contacts us from Texas, and they're younger. 36 years old. So the note from our paralegal says that he was the son of one of our clients. And apparently he lost his vision and applied for Social Security disability. He's still pending application. He hasn't received it yet. And the mom is supporting him while he's waiting to get it. They live in the same apartment complex. He has credit card debt, and he also owns money from a repossessed vehicle. May have been sued, looks like. We told him what we did, and we waived his fees and enrolled him in help so he doesn't have to deal with the creditors anymore. So person contacts us from California. They're 75. They get $2,150 approximately in Social Security and a little pension of about $100. They called us. When people call helps, we ask them some basic questions. Like where you live, you married or single. How'd you find out about helps? Have you been sued? Are you buying a home or renting? Buying a car? Own a car? What do you owe approximately in debt? Some basic questions. Do you owe any income taxes? We ask basic questions. We save that information. Then we read you what we do, and we quote you the fees. Fees for helps are minimal. We don't turn anyone away that qualifies for our help. Most a person would pay would be $40 for 24 months, $20 for 24 months, free thereafter, or it could be $30 for 24 months, $15 for 24 months, free thereafter, or $20 for 24 months, $10 for 24 months, free thereafter, based on your household income. So this person, we also inform them about, send them an email about Section 8 housing and why their bank account was protected. The person owes $37,000 to Discover and about $6,500 other credit card debt. So she owes Discover. It's guaranteed she's going to get sued. She wants to keep the credit cards with her bank as the payments are low, but she could change her mind. So one of the things we ask people when they enroll, do you have a credit card with a small balance or nothing is owed that you still want to keep? And if you do, you can keep that credit card as long as it's not backed by a bank where you have another credit card or loan that you're not going to pay. Banks don't care about your other debt as long as they're getting paid. She rents but wants to move to less expensive housing if she can find it. She has an old vehicle and no real estate. Income and Social Security, a little mineral rights, and small pension. I talk to people occasionally that have little income from mineral rights. Is that exempt? Probably not. Depends where you live. But I'll tell you this, in 46 years of legal practice, I've never, in tens of thousands of bankruptcies and helps for the last, since 2012, I haven't seen anyone try to garnish a person's mineral rights. They don't do it. No way they'd even find out about it. So Wendy asks, if they garnish your bank account and your account has over the protected account, but the amount over isn't as much as what you owe the creditor, will they take it? If the money that went into that bank account that's over twice the amount, if it came from a protected source like your pension or Social Security, Wendy, you can file what's called a challenge of garnishment or claim of exemption. We help people do that when that happens. It doesn't happen very often because it's easy to keep the amount in your account less than twice the amount of your Social Security. Generally, you can file a challenge of garnishment, claim exemption, and the court will order that money not be given to the creditor. Okay. Will they do it again? Well, it's theoretically possible, but highly unlikely. If they're not going to get any money the first time, they usually don't try to do it a second time. We don't see people being garnished multiple times. Doesn't happen. Um, People who say they're struggling and can't pay credit card but are worried about going over 2 times their Social Security is a mystery to me. The day mine hits, it's gone. Well, that's what I hear all the time when I tell people, keep it less than twice the amount. A lot of people say, Eric, no problem with that. It's gone. Don't need to worry about it. But some people might have more. So I tell them what can be done if that's the case. Thank you, Freedom. Freedom says they had a car repossessed 14 months ago and they haven't heard anything about it. Now, you could theoretically get sued down the road. You know, helps our assistance, but it won't matter because your income's protected. Helps assistance is not just one time, it's ongoing. And one of the reasons it's ongoing is because occasionally our client would get sued, maybe even 2 or 3 or 4 years after the debt became due. Doesn't matter. But or even longer, we're still represent you so that if you did get sued and someone knocked on your door to see you with legal papers, you contact us. We explain to you why you don't need to go to court. We'd send you an email with links to articles and videos explaining why your income is protected, why you won't need to go to court. And then we contact the attorney that sued you, letting them know that your income is protected. Tell them that we understand they're going to get a judgment. Remind them of your protected nature of your bank account, although we don't need to do that because it's protected automatically by your bank. So don't worry. So if you are worried, you don't need to worry about taking money over twice the amount unless someone sued you and gotten a judgment. And then once again, if they did garnish your account, you can file, like I said, paperwork to get it released. But if you didn't want that to happen, you could just pull that extra money out and hold it either in cash or cashier's check or preloaded debit card, whatever. So it shouldn't be a problem either way. Okay? And you can always call and talk to us about it. Okay. Person contacts us from Michigan. Their age is 75. They get $1,725 in Social Security buying a home. They owe 75,000 is worth 120. And they say, I'm on disability and stop sorry, being able to pay my credit card bills a year to a year and a half ago, depending on the card. I just was served with papers from one of the cards. I got sued. Most have charge off on my credit report. It shows I owe anywhere between $5,000 and $45,000. Your credit report isn't going to show all your debt. But anyway, it says the $5,000 is current debt through my credit union. It's the only one I'm paying on, and at the minimum, it's not going anywhere. So they called us, and then they called again. This is before Christmas. We called several times. We explained what we did. And it looks like they enrolled in helps. Now, they could keep the card they have with their credit union if they wanted, if they don't have another loan with the credit union. It's a pretty large amount, $5,000. If they can't afford it or if they later change their mind, they can always turn it into helps later. We send a cease and desist letter. But if you owe the credit union and you're not going to pay them, you're going to want to change to a different bank account because they're not going to let you bank there. Now, a regular bank would, but a credit union won't normally. They would kick you out, or they would try to take money from your account that was deposited in there to pay towards the debt. Whether you realized it or not, when you signed up for that bank account or that debt with the credit union, one of the small print in the loan or in the credit or in the checking account application says, if you owe us money and you don't pay it, we're allowed to set off money from your account to pay a debt that you owe us. Banks don't do that except for Truist Bank. Other banks won't, but credit unions do. Okay? So what if you default on one credit card? Will other cards allow you to keep the other card to use, especially with high balances? Well, they will. It's not normally the practice of a credit card to cut your credit card off if you don't pay another credit card, as long as they're getting paid. Now, it is possible they might lower the balance you have to borrow on the credit card, but normally they wouldn't cut you off. Okay. When they ask, is there a minimum amount owed that creditors usually won't go through the process of suing to get a judgment? Seems silly for them to do that for a small amount. There probably is. It I've seen a lot of lawsuits for $500 or $600. Uh, but you're right. It's probably more likely that they wouldn't sue you if it's a real small amount. But there's no automatic minimum. Yeah, and Turbo makes a good point. When a creditor sues you, they have to pay a filing fee. I talked about this, I think 2 days ago, about the increase in number of lawsuits being filed against people, no matter what their age. One of our attorneys told us that December, the number of lawsuits filed against helps clients actually went up, which usually in December goes down. But year by year, the percentage of seniors getting sued and probably persons in general is going higher and higher. But I always tell people that seniors that are getting protected income, it really doesn't matter if you're sued or not. They can't collect from you, and you're not going to have to go to court. Okay, it's not. It's probably less likely that you would be sued because if you're enrolled in helps, because we send a letter out to those creditors letting them know that your income is protected. So it doesn't really make sense for them to sue you. And like Turbo says, they have to pay a fee to sue you, a certain amount of money. Now you might get sued in small claims court, or you might in regular court, but it costs them money to sue you. Um, a couple states, Maine, for example, passed a law, and if you're a debt collector and file a lawsuit in Maine, for example, then you have to pay a premium for filing the lawsuit. And what they do with that extra money, they pay it back to the state for the cost of the courts, because the filing fee for filing a lawsuit does not cover all the cost of a court. In some courts, 3/4 or 4/5 or even more than that of the lawsuits filed are collection lawsuits. So it takes a lot of court time to do that. So in Maine, they're charging a premium to creditors, and then part of the money they're charging them they're taking and giving it to nonprofits. Okay. When we get big enough, we may want to see that legislation gets passed in other states as well, to discourage these debt collectors from filing lawsuits. But you don't need to worry if you're sued. Your income's protected. That's one reason why our help is ongoing, because we know that that occasionally our clients will get sued, even though we let the creditors know that their income is protected and safe. So Katrina says, all my creditors sued me except one. I have 5 judgments. That's unusual. Up to about a year ago, or 8 or 9 months ago, a lot of times I would give a percentage of how many often you would get sued. And then the attorneys that helped told me to stop doing that because people were upset because more than the percentage I said was suing them. And they said, Eric said it only this percent, but it's higher than that. So I don't give a percent, except to tell you that you don't need to worry. And if you do worry, you pick up the bloomin' phone and you give us a call, no matter how often. That's what we're here for. City said, blight tickets to collections, can they garnish you? Are you protected? I don't know what a blight ticket is, but your Social Security is and your pension is protected from any debt you owe to the city for a ticket, parking ticket or whatever. I guess the only problem you would have with a government agency having to do with tickets is maybe it could affect your driver's license. Not always, but in some states it could. Banks have attorneys on salary so they keep them busy. Some do 6, some don't. The bank's paying their legal stuff anyway, so they keep them busy. Yeah, some attorneys, some law firms may work on an hourly rate, a discounted rate as collections. Some attorneys who do collections get paid a percentage of whatever they collect. Sometimes a creditor might pay the attorney a flat fee for a lawsuit and a little bit extra if they're able to collect it. It depends. Bottom line is you don't need to worry. Okay? And if you do worry, you call us. So this person calls us from Oklahoma. Their age is 72. They get $1,100 in Social Security. The rent is $300. They said that her purse was stolen in July. They took all of her cash, $400, and credit cards. She attempted to reach out to the credit card companies to dispute late charges and fees. Credit card companies did not listen and are still adding all of the above. They're calling her all the time and sending her letters. Before this incident, she had a 700 credit score. Her rent is going up next month. We went over what we did, and we sent her a packet, and then she looked at our videos, then called back. Looks like maybe yesterday. And after she read everything and examined us, she decided to roll in helps. So she doesn't have to worry about paying the credit card debt. And that's if you're getting Social Security or pension, disability, or VA benefits and you're struggling, your income is protected. You don't need to pay debt. Congress protected your income from debt collectors. They did it for a reason. They wanted seniors to have money for their food, their rent, their medicines. They don't want you to go without. Okay? So you're going to be okay. And then they also didn't want you to be harassed by creditors. So that's why they passed the Fair Debt Collection Practices Act, so you could be protected from collector harassment. Okay? Okay. Person contacts us from Oklahoma. They get $1,300 in Social Security and a VA pension of $2,200. They have $50,000 in debt, which is a lot. The payment on that is going to be $700 a month, at least. And then they have a deficiency from a car that got repossessed. They were considering bankruptcy. Then they found out about us, and that explained why they didn't need to worry. They enrolled with helps. Bankruptcy, we have emails that talk about bankruptcy versus helps. I mean, like I explained, I probably filed between 30 and 40,000 bankruptcies. But seniors, the vast majority don't really need to file bankruptcy, and especially if they're modest income, they can't afford bankruptcy, or bankruptcy can get them into trouble. How do I say? Why do I say that? Well, let's say you have a home that's worth 200,000, and you only owe 50,000 on it for whatever reason. Okay, and then the exemption for your state is 50,000. So if you take 200 minus 50, what you owe, you have 150,000 equity, but your exemption for your state is only 50,000. Therefore, you have 100,000 equity in the home over and above the state exemption, which means if you file a bankruptcy, a trustee could say, "Hey, I'm going to take your home. I'm going to sell it. I'm going to pay you your 50,000 exemption that you're allowed under state law, and then I'm going to take the rest of the money, pay your creditors, and whatever's left, I'll give to you." But what are you going to tell me? I don't want to do that. I want to stay in my home. So, a bankruptcy attorney would tell you in that instance, you can't file a regular bankruptcy, Chapter 7, but you could file a Chapter 13. But the problem with a Chapter 13 is if you owed $50,000 in debt, you'd have to pay all that off over 5 years. Payment could be easily at least $1,000 a month. And you'd say, well, I can't afford to pay $1,000 a month. Well, that means you can't file bankruptcy. But you don't need to file bankruptcy, because if you don't pay the debt, even if these creditors were to sue you and get a judgment, it's not their practice to come after your home. And maybe you own it jointly with a spouse. No, there's a lot of reasons why your home's going to be protected, even if you have equity over and above the homestead exemption. Um, I'm talking practical. What happens in practical matters. And if you added one of the kids' names to the home as joint tenants with survivorship rights, then that means when you pass away, the property automatically goes to the kids. There's a lot of reasons why seniors don't need to file bankruptcy or shouldn't file bankruptcy. Now, sometimes it might make sense. We don't file bankruptcy. We would tell you that. We give you the information. You can make a decision. Okay. So Rico says, seems once a bank sees someone on the county search, assuming that they've been sued and defaulted, that they would not pursue getting in line themselves. Well, maybe some of them do that. I don't think all of them do it. I think a lot of creditors sue just because of artificial intelligence. It's easy to file a lawsuit. It's easy to print out the paperwork and pay someone to serve the papers. And, it doesn't take any brains to push the computer to push in the numbers for a lawsuit to be generated and the paperwork to be given to a sheriff's deputy or a process server to serve it. And then they count on the senior not knowing their rights and being nervous and calling them and making arrangements to make payments. But that's why you're listening to me. You know your rights and why you don't need to worry. So Freedom asks, what happens with a 1099-C that I did not file last year? And I no longer work, so I'll never file taxes again. So what about the 1099-C? So what a 1099-C is, that's a form that a creditor can file with the IRS. You're supposed to file it if you have debt over, I think it's $600. That lets the IRS know that you didn't pay this debt, and therefore this debt that you owe should be counted towards you as income upon which you would pay taxes. Well, we don't have a lot of problems with our seniors in 1099-Cs. Okay, a lot of them get these 1099-Cs. And if you're not required to file taxes, IRS doesn't do anything. I mean, I don't see them doing anything. Okay. Why is that? Well, I think maybe the computer tells the IRS that, hey, they can tell what your income is, and your income's so low that even if you were to file taxes, that your income, you don't reach a certain criteria you would owe, and even if you did, that your income is low enough that you could get on currently not collectible status with IRS and not have to pay the taxes. So they don't follow up on it. Now they could, and you could always deal with it later, but I just don't see it happening. So brings us to something I talk about sometimes. There's the law, technically what happens, and then what happens on the real world. Where I drive, the speed limit is 70 miles an hour. But I swear half the cars are going 80 or more, 85. They go fast. Okay. Now, do I see anyone getting pulled over for going 15 miles over the speed limit? No, I don't see it. So even though the law says a certain thing, doesn't mean it's going to be enforced. And that's a lot of this stuff. So, but you could scare people into thinking that they're going to get into trouble if they get a 1099-C. So I wouldn't worry about your 1099-C. We have videos on it. I did a video with one of my former partners probably 3 years ago on February 9th with Rex Daines on 1099-Cs and why they're not an issue. Thanks for the kind words. Appreciate it. Okay. Chicken asks, does a judgment on your home prevent you from selling it without paying the judgment? Well, it depends. A lot of it depends on where you live. A judgment can become a lien on your home. In certain states, there's ways to remove a judgment lien. Like Florida, you can file paperwork. They have pretty much an unlimited homestead exemption, and you file to get the lien removed. Texas, California, if you've homesteaded the property, the lien doesn't attach. In some states, you can get the lien removed by filing a bankruptcy. In some states, if you go to sell the home and there's a lien, then it would get paid from the proceeds of the sale. In other instances, maybe you have someone else's name on the title with you as a joint owner with survivorship rights. Judgment just against you as a senior, and then when you die, property automatically goes to the co-owner. And as long as they were a co-owner on the property, a joint owner with survivorship rights, before the judgment was obtained, then when you die, the property automatically goes to the co-owner and the judgment lien disappears. So there's a lot of reasons why a judgment lien won't be a factor Okay? My accountant told me if I get a 1099-C to file it. Well, if you file tax returns, you can. And if you end up owing taxes, your income is low enough, you get on currently not collectible status. But if you're not required to file taxes, I wouldn't worry about it. Okay, I'll talk about accountants for a minute. Accountants are great. We love them. Except when I was doing bankruptcy, we used to tell people that, you know, what is there, 52 cards in a deck of cards? I used to tell people, well, accountants have, if we're playing we're playing cards with accountants, they have 40 cards. A bankruptcy attorney, we had 52 cards. We had all the cards because there was a way to get taxes eliminated if they were a certain age and certain old taxes. So, accountants just want to do everything carefully, exactly right. But sometimes you don't need to do that. Okay? So that's the scoop on 1099-Cs. Rico says, I had a process server a month ago, gave up trying to serve me, so I just noticed the court dismissed the suit, but think they'll get another shot to serve. They said my house was environmentally hostile. Okay, so here's the deal. In some states, you file a lawsuit, they have to serve the have to serve you within a certain amount of time. And if they don't, the court doesn't like that, and so the law allows the court to dismiss the case. They call it dismissing it without prejudice, meaning they could file the lawsuit again. But usually, if they file the lawsuit again, they have to pay another fee. I remember talking to a lady who was a helps client, and she was being sued, and the sheriff kept calling her and saying, "Your gate is locked. I can't serve these papers unless you come out and unlock the gate. Will you please unlock the gate?" And I told her, I said, the law doesn't require you to unlock that gate. It could have been a private process server too. You don't have to make it easy on them. I don't know whatever happened. I can't remember. But no, if they can't serve the lawsuit in a lot of states, the case will end up getting dismissed. And you don't need to make it easy for them. But you don't need to make it hard for them either. If you get sued and they get a judgment, they can't really do anything to you, as I've explained. How many judgments are renewed? And the person says at Pennsylvania. I don't know if there's a way to statistically to find out. I would, I would, a lot of states provide that if they get a judgment, it's good for so many years, and then it can be renewed. In some states, it can't be renewed. Sometimes it can be renewed one time, and then that's it. Other times, it can be renewed over and over again. I don't think there's a way to guess on how often that happens. I suspect that it happens fairly regularly. Okay. So, person contacts us from Oregon. They're 78. They get Social Security and a pension only, private pension only. Rent. They own a truck outright. Stopped paying 3 credit cards and has a new lawsuit with Citibank. You read what we did. They enroll in helps. And that's it. We sent them they don't need to worry. Their Social Security and their pension is protected. No one's going to take their truck. They don't have to worry about the 3 credit cards they owe. Person contacts us from Massachusetts. Way back in 2020 and 22. Trying to figure out where to live with her father that was really elderly. She had a bunch of credit card debt, and she was paying the minimum amount. Says she's going to have to go back to work so they can afford to move out of where they're at now. Sent them what we did. Her biggest concern was finding a place for them to live, which I agree. That's a nice thing about helps. If you don't have to pay the credit card debt or these other debts, you have money for the rent that you need. It says if she wants to use this for her debts, she'll call back. And then it looks like she called yesterday. Has a payday loan, credit card debt, has some wages. I know in Massachusetts, I think I looked at yesterday, you can make like $650 at least a week that's protected from garnishment. Her dad had passed away in the interim in the last 3 years. And when that happened, she lost his income and lost the assistance she was getting for being his caregiver. On the verge of being evicted. She was getting rental assistance, but not getting that anymore. Well, yeah, we explained that she wouldn't need to worry about the old debt. I can't help her with the rent, but I think she's got that worked out. Okay. Okay. Person contacts us from Kentucky. Their age, a husband and wife. They both are 66 years old. He gets about 1,900 in Social Security, and she gets 900 in Social Security disability. She said, disability is our only income. I have credit card debt and one unsecured loan. I can't afford to pay them anymore due to medical supplies costs and doctor copays. Travel to and from the state for doctors. So thank you for the help you give seniors. We are both 66 years old. Uh, we explained why they didn't need to worry about the debt. We mailed them a packet. I think they probably enrolled in helps. That's why I'm reading this. So this person contacts us from Utah. And she got on the phone with us with her fiance. They're going to get married. And worried about a loan she has. And will he be responsible for the debt when they get married? No, no. He has a fifth ill, would like to surrender it, can't afford the payment. Pay almost $1,000 and for another 20 years. They called back in November again and can't afford the credit card debt. They were worried about 1099-Cs, explained to them why they didn't need to worry, probably explained to them the same thing that we just explained with you a few minutes ago. So it looks like they enrolled in helps, or she did. Person contacts us from Maryland, 67. They get Social Security and a pension and $700 in wages and renting. Enrolled with Freedom Debt Relief Program. Been with them for several years. The last debt has gone to a law firm they use. The amount is $24,000, almost $25,000. According to Freedom Debt Relief, he says the balance I owe is $35,000. And apparently he says, the law firm National Litigation Law Group contacted the creditor and said the best they could do was a settlement of $30,000. Plus, they need an additional $1,200. Sorry, but to me, this isn't any type of help or relief. Was wondering if your firm could help me. Well, yeah. If your only income, Social Security, and a pension, your wages are protected in Maryland based on the amount that you say that you are receiving. You don't need to pay this debt relief company. My question, if you're signed up with debt management or debt settlement company and you're a senior, did they tell you that your income was protected, that no one could touch your Social Security or your pension? If they didn't tell you that, you weren't given complete information. That if they would have told you that, you would have realized you didn't need to enroll with them, and they wouldn't be making money from you. Okay. Person contacts us from Texas. Their age is 78. He gets 1370. He gets 13, almost $1,400. And his wife gets $1,000. He's married, but wife has no debt. Um, they only get Social Security. They have individual bank accounts. They own a home outright. Um, so in Texas, has an unlimited homestead exemption. It's not going to be an issue, and there's a way to get the lien removed if they go to sell the home, or if he dies before her, it's going to go into her name. And they own a car outright. Uh, they have credit card debt and a personal loan with auto payment. We explained how they could stop the auto payment. Read what we did, and they enrolled in helps. Pretty easy. It was just his debt, and he only get $1,400 a month. He doesn't have to pay it anymore now. He won't have to make those payments. He'll use that money for their food and their medicine and the necessities. You know, seniors would pay their debt if they could, but a lot of them just can't afford to pay it. And if you're in that position, you don't need to feel guilty. It's just the creditors charge interest for a reason. They know a certain percentage of the debts are going to go bad. Okay, person contacts us from Alabama. We're getting near the end of the year. I will talk to you again on Monday. Alabama, age of 73, has 17,000 in debt, income of Social Security of $2,000, and owns a mobile home on land. You're right. Press the like button or subscribe to our channel. A lot of people find out about helps from these YouTube live videos. Are we going to be open on Friday? I think the office is, yeah. We don't do YouTube live on Friday, but I'm thinking we're planning on being open on Friday. Answering phones. I'll probably be on the phone on Friday talking to people. Person says, I has one credit card debt and only one secured debt. Was a bit worried about how they could come after them. Made sure he knew his rights and his bank account protection. Called back on December 29th. He's ready to get enrolled. He is currently with Accredited Debt Relief. It's another debt management company. Read paragraphs, and these debt management companies, we talked to so many of them, and none of them tell people that their income's protected. I'm pretty much on the end of what to talk about today. The other notes I have are pretty long ones. They're kind of boring. So I'm gonna call it quits today. I want to thank you. If there's a question, Eric, if a client needs help to fill out legal papers, do you help with that? We don't give legal advice, but we give legal information, and yes, you can give us a call. Okay, you bet. That's what we do. We don't we don't give advice on how to defend a lawsuit, but if there's a judgment against you and there's some paperwork, yeah, we'll tell people, we'll give them information. We have links to that'll help them do that. So give us a call. Don't don't think that we don't aren't it's not what we do. Give us a call and we'll be able to talk to you about it. Okay? So thanks for your participation today. Be sure and call us if you have any questions. Have a good, safe New Year, and I will be talking to you on Monday. God bless. Have a wonderful day.